Court calls the case People versus Samuel Allen Dabney.
Ready, Judge.
Good afternoon, Your Honor. Laura Grant, on behalf of the people.
Good afternoon, Judge. Attorney Kerry Mitchell appearing on behalf of my client Samuel Allen Damon, who's approaching to my right. Today's the date set for a preliminary examination, Your Honor.
Nope, right here. Nope, switch.
That's right. Yeah. All right. Today's the date set for an exam, Judge. We're going to waive that examination. My client understands that he has a right to a preliminary examination, and that if an examination was held, the people would have to show that a crime was committed and that he probably committed that crime. He wishes to waive those rights.
Your Honor, I did discuss this with defense counsel, and we discussed that I would be filing an amended information with the corrected counts. May I approach with that information?
That is correct, Judge.
So
So we would be waiving as to counts 2 and 3, and count 1 would be dismissed. Counts 2 and 3 are child sexual abuse of material and aggravated possession, the 10-year felony.
okay,
20-year
I
felony
see.
is being
So he's the original charge. Let me go to
with 75145C2, which is a 20-year felony, Judge.
I got that.
Oh, okay.
So I'm just going on the count. So count 1 is going to be dismissed. He's waiving up on counts 2 and 3.
That's correct, Your Honor.
All right.
That is correct.
You understand that, young man?
Speak up.
Yes,
All right. And you understand that you're waiving your right to a preliminary examination where the people would have to show by the standard of probable cause that these offenses were committed and that you committed them.
yes,
Okay. And you understand you're not going to have that hearing and you'll proceed to circuit court for further resolution.
yes.
All right. People also waive their right.
Your Honor, as to the matter of bond,
Oh, hold on a second. Preliminary examination having been waived, defendant is bound over to circuit court on counts 2 and 3. Count 1 is dismissed. Yes, go ahead as to bond, but as to the circuit court arraignment, you waive formal reading of the complaint
yes, Judge.
or the information. Stand mute at this time.
Yes, Judge.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
January 15th at 1:30 with Judge Slay.
January 15th, 2026, 1:30 before Judge Slay. Yes, as to bond.
Your Honor, as to the bond, I believe that the bond is really excessive. It's $500,000, based upon the amended charge, which is basically half of what he was facing. I believe an appropriate bond, and also my client has no prior criminal history whatsoever. I would respectfully ask the court to place a more reasonable bond considering the circumstances. I believe I'm not asking for a personal bond, Judge. I respectfully ask the court to give him a bond, possibly $25,000, 10%. 500,000, I believe, is really accessible. I don't know if the court remembers. It probably had 1,000 other cases since I last argued.
No, I remember you.
Oh, okay.
And maybe that's a good thing or a bad thing, but
Yeah.
I remember.
Well, I was hesitant because I gotta catch a plane tomorrow. I don't want to get locked up today, so otherwise I wouldn't mind. But
Well, maybe they'll hold the plane for you if you keep on.
May I?
Yes.
I would object to a change in bond. I did, Detective Morrison from Washington County is the officer in charge of this case, and I did speak with her today. She did a review of Mr. Allen Dabney's phone, and both in the report and in my conversation with her said that he had an overwhelming amount of child sexually abusive material on his phone. And it was accessible by her, not a forensic analyst. Just in reviewing his phone, he had an overwhelming amount of both images and videos, and prepubescent children. I think given that this bond is appropriate.
yeah, I'm not going to go
Go
into everything that I said before. He was in a relationship with an individual. This individual, I believe that given the circumstances and the bond is just really excessive. I don't want to get into the other underlying facts about, and the people know that this other person that was the target of this investigation is the main character in this situation.
Let me ask this, and I understand that there have been a change in charges. I also know that sometimes when that happens, when there's a waiver up, it's a waiver up on 2, but given what would be this overwhelming amount of stuff, and again, I don't know what that is or necessarily quantifiably means, could there be potential other charges?
I mean, certainly.
I mean, I'm not suggesting it, I'm just trying to get a
Yeah,
feel
I
for
think, it was
Yeah.
not, in my viewpoint, charged correctly at the outset. And so part of this was to ensure that he was waiving up on the correct charges. But yes, I mean, he's waiving up on counts 2 and 3, but technically every image, or photo or video that he had could be another charge. So the answer is yes. As to like a different charge, I, at this time, don't think so. This did originate as a Canton investigation into, yes, correctly, a wider ring of people of which the defendant was part of. And he was residing in Ypsilanti, so that's why this case is.
And just
saying.
briefly, Judge, the person that he was involved with that originated in Canton, those individuals were referred to the federal system and they were prosecuted in that realm. He is the only one that was not, and that is because he was not, in their opinion, a main character in this.
When you say they're the federal.
Correct.
Okay.
Correct, Judge. So, and I'll get into this when it gets to circuit court, but in relationship to them being on his phone, this other individual that got charged federal had access to my client's phone.
Having heard everything in this, I will reduce the defendant's bond. I'm going to grant the motion in part, but not nearly to the extent that the defendant wants to reduce. I'll reduce his bond to a $250,000 cash surety bond.
Court consider 10%.
If I would have said it.
Okay, well, I want to catch that plane, Judge.
Yes. You're doing everything to not, but no, I will not consider 10%. Thank you.
Have a good day.
Calls case People versus Terrence Weatherspoon.
On behalf of the people. Assistant Public Defender Ben Dunn on behalf of Mr. Weatherspoon, who is joining me at the podium now. And sir, would you state your name for the record, please? Terrence Weatherspoon. Your Honor, we've worked out a deal involving a waiver and a plea at circuit court in this matter.
Correct, Your Honor. My understanding is that Mr. Weatherspoon will waive his right to a preliminary examination. The people will not file a vigil in this matter. And in circuit court, there'd be an offer for a plea to an added count of possession of less than 25 grams of controlled substance.
We've got a problem. Mr. Allen. Have his bond violation?
I do. So, well, can I address it on the record, Your Honor?
Yeah, go ahead.
I talked to my client about it. His position is that he was incarcerated. And, I think he admitted the first violation, to Your Honor. He denies this one and he's paid, I believe it was $150 for the sample to be retested at a lab. So, given that the retesting is in progress, I'd ask the court to defer any action to Judge Conlon, and perhaps we'd have those test results back in 2 weeks, or if they came back later than that, I'm sure the government would be addressing it regardless.
Does he have a medical marijuana card?
No, I don't. That was why I had last time I asked you, I told you about the appointment. And that was the whole thing. So we trying to get a medical marijuana card right now. I got a doctor appointment scheduled on February 11th for all of this. In the cocaine drop, I don't see how it was positive, and I'm supposed to test today too, actually. So I'm trying to figure out how. I don't understand how is it dirty. That's why I paid for it to get tested again. They told me it'd take up to 2 weeks for it to come back from California. And regards to
Well, maybe if that's the case, I mean, except that, and here's the problem, counsel, I might wait, except that his last 3 tests have been positive for cocaine spanning from November 17th to December 26th. THC leaves his system and then he's
it's
back with THC in his system again.
I speak, Your Honor.
All right, if your attorney wants you to, I mean,
Don't talk about anything before November, but I
The-
think we're fine talking to the court about his substance abuse issues. He's pretty open with it. You know, he admits he has an issue. I'd just say to the court, I think THC opinions have evolved, and you know, I haven't known Mr. Weatherspoon very long, but he's pretty obviously in pain to me. Frankly, I think THC is better for a person than taking opiate pain relievers. He can barely walk. I mean, I think he needs,
that's good, doctor. I don't know.
he had a
I'm
doctor
trying to
appointment.
debate that issue. That's not it. And it may very well be, but that's why he needs to just get a card, and then there isn't an issue.
I scheduled to make an appointment for the card. In the cocaine dirty, that's why the first time I told you, I said, Judge Simpson, I did that. This time I'm 100% sure I didn't do any drugs. So that's why I had it sent out for the test, because I know I can't be dirty for it. Would you allow me to take a test today to, like, I know I'm not dirty. I ain't using no drugs, man.
My name's not man.
Yes, sir. I'm sorry, sir, but I'm sorry, sir.
Just don't judge is good.
And if it comes back dirty, I just leave you in there forever.
Ever is a long time.
I
sir.
know, but we're gonna make a deal. Let's make a deal.
Let's make a deal.
Is that it?
Deal.
If you come back clean, then I get to decide what to do. Test. Let him know he's coming over to test.
Where's he going? To community
Community
corrections?
Any corrections?
All right. Obviously, if you want to come back, work out. So, come back